Cheatham versus Pohl, Supreme Court of Indiana, 2003, on page 567 of Prosser, Wade, and Schwartz. Torts case is a material. After Doris Cheatham and Michael Pohl divorced in 1994, Pohl retained photographs he had taken of Cheatham in the nude, as well as photographs of the two engaged in a consensual sexual act. In early 1998, Pohl made photocopies of the photographs, added Cheatham's name, her work location and phone number, her new husband's name, and her attorney's name, and proceeded to distribute at least 60 copies around the small community where both he and Cheatham still lived and worked. Cheatham sued, alleged an intentional infliction of emotional distress, and the jury awarded her $100,000 in compensatory damages and $100,000 damages. Indiana Code 345136, enacted in 1995, provides A, except as provided in IC 1325-410, when judgment that includes a punitive damage award is entered in a civil action, the party against whom the judgment was entered shall pay the punitive damage or the action is pending. B, upon receiving the payment described in subsection A, the clerk of the court shall 1. Pay the person to whom punitive damages were awarded 25% of the punitive damage award, and 2. Pay the 75% of the punitive damage award to the Treasurer of State, who shall deposit the funds into the Violent Crime Victims Compensation Fund established by IC 526.1. Cheatham argued that the new statute providing 75% of the punitive damages be paid to takings clauses found in both the Indiana Constitution and the Fifth Amendment of the United States Constitution, and that it violated other provisions of the Indiana Constitution. I. Punitive damages in Indiana. In assessing the claim that the allocation statute takes property without just compensation, it is essential to understand the nature of a claim for punitive damages. The purpose of punitive damages is not to make the plaintiff whole or to attempt to value the injuries of the plaintiff. Rather, punitive damages, sometimes designated private fines or have historically been viewed as designed to deter and punish wrongful activity. As such, they are quasi-criminal in nature. As a matter of federal constitutional law, state legislatures have broad discretion in advising and limiting BMW of North America, Inc. vs. Gore. Victims in a criminal case have no claim to benefit from criminal sanctions. It has been consistently held that civil plaintiffs have no right to receive punitive damages. To the extent punitive damages are recoverable, they are a creature of the as we have repeatedly held in other contexts, the legislator is free to create, modify, or abolish common law causes of action. As a matter of federal constitutional law, no person has a vested interest or property right in any rule of common law. As a result, the General Assembly is free to eliminate punitive damages completely, as other states have done, and also has wide discretion in modifying this quasi-criminal sanction. Indeed, several jurisdictions have chosen not to recognize punitive damages as an acceptable award in any form. Indiana, like several other states, has chosen an intermediate ground, permitting injuries to award punitive damages and thereby inflict punishment on the defendant, but placing restrictions on the amount the plaintiff may benefit from the award. The facts warranting punitive damages must be established by clear and convincing evidence. Whether punitive damages may be awarded is usually a question of fact. In sum, Indiana law recognizes a right to assert a claim to be compensated for a cognizable wrong and to recover on that claim to the extent the law allows. But a number of consequences flow from the fundamentally different nature of a claim to punitive damages. The condition of the defendant is relevant. C. There's a lot of C's in this text. So, anyway, which The financial condition of the defendant is relevant, which it would not be if the goal were to compensate the plaintiff as opposed to deterring or punishing the defendant. Footnote admitted. Proof is required by a clear and convincing standard rather than a preponderance of the evidence standard. For our purposes, the essential point is that because punitive damages do not compensate the plaintiff has no right or entitlement to an award of punitive damages in any amount. Unlike a claim for compensatory damages, the trier of fact is not required to award punitive damages even if the facts that might justify an award are found. Claims under state and federal takings clauses. So this is the analysis of, I suppose the other, if I read it slowly, is that the plaintiff argued that the new statute providing 75% of the punitive damages be paid to the violated the takings clauses found in both the Indiana Constitution and the Fifth Amendment of the United States Constitution, and that it violated other provisions of the Indiana Constitution. We talked about punitive damages in Indiana first, and now we're talking about claims under state and federal taking clauses. Any interest the plaintiff in a punitive damage award is a creation of state law. The plaintiff has no property since state law creates a property right. The Indiana legislature has chosen to define the plaintiff's interest in a punitive damages award as only 25% of any award, and the remainder is to go to the violent. The award to the fund is not the property of the plaintiff, nor is her prejudgment claim a property interest. Rather, the claim she had before satisfaction was, pursuant to statute, a claim to only 1/4 of punitive damages. As a result, there is no taking of any property by the statutory directive that the clerk transfer a percentage of the punitive damages award to the fund. A claim for punitive damages can be sustained by a viable claim for compensatory damages. Cheatham thus claims that an award for punitive damages is connected to a claim for actual damages. From this, Cheatham reasons that because she has a right to compensation, she must have a right to punitive damages as well. This confuses necessary preconditions with different sufficient ones. To be sure, a claim for compensatory damages is a prerequisite to a claim for punitive damages, but it does not follow that it is adequate to confer a right to that claim. Several states have statutes that allocate punitive damages to the state in some form similar to the Indiana version. In BMW of North America, Inc., to opinion of Ginsburg J., dissenting opinion Ginsburg J. of the state courts that have addressed the issue, only the Colorado Supreme Court has found an unconstitutional taking of property, while statutes in Alaska, Oregon, Georgia, Florida, and Iowa have been upheld. The court concluded that neither the takings clause of the Indiana constitutions nor the other provisions of the Indiana constitutions were violated by the statute, and the judgment of the trial court is affirmed. So in the notes and questions section for this case, we read 1. Intentional torts. Punitive damages are generally permitted when defendant has committed an intentional tort such as assault, battery, false imprisonment, conversion, trespass, malicious prosecution, or intentional infliction of emotional harm, as the defendant did in the principal case. Defendant's conduct need not be motivated by personal hatred. It is enough if it has the character of outrage. In Jones v. Fisher, Wisconsin, 1869, a couple forcibly removed denture from former employee's mouth to hold as collateral because they had loaned her the money to have the dental work done and were upset when she quit her job before she had paid the money back. Malice can be inferred from a conscious indifference to the consequences of conduct. Yeakley v. Doss, Arkansas of 2007. Defendant had admitted that he was intoxicated at fault for an automobile accident. Plaintiff entitled to introduce evidence of 2 prior DWI convictions in support of claim for punitive damages. But there are still times when a technically intentional tort may be committed without malice. For example, an article or falsely imprisons a person whom he unreasonably believes to have stolen his property or unwittingly operates on the wrong patient. In one case, couple seeking to adopt specifically asked for a healthy infant from a healthy family. Adoption agency, pursuant to a policy of not disclosing family information if it was not hereditary and might interfere with the bonding between adopted parent and child, told them baby was healthy and did not tell them that baby's biological father was schizophrenic and that baby's biological mother's father had been hospitalized for treatment of schizophrenia. Adopted baby had numerous behavioral problems as a child and as a young adult was diagnosed with paranoid schizophrenia. A couple filed suit against agency for fraud, wrongful adoption. Court found that trial court's taking of summary judgment on behalf of agency on punitive damages claim was appropriate. Although the actions were intentional, they were just vindictive and thus did not warrant punitive damages. Ross v. Louise Wise Services, Inc. In number 2 of notes and questions, we discuss negligent torts. Conduct short of intentional wrongdoing also may be sufficient to justify punitive damages in most jurisdictions. Courts use a variety of formulas to spell this out, including reckless disregard for the rights of others. From Almond v. Bird, Kansas of 1960, or willful misconduct, wantonness, recklessness, or want of care indicative of indifference to consequences. In re air crash disaster near Chicago. Certiorari denied. Conduct, and that was in 1981. Conduct that is merely negligent, even if it causes severe damage, is insufficient to justify punitive damages. This is usually held to be true of grossly negligent conduct when that term is used as a synonym for extreme carelessness as opposed to recklessness. From Doe v. Isaacs, Virginia 3, we see conduct when that term is used as a synonym for extreme carelessness as opposed to recklessness. Sorry, I just read the wrong thing. Conduct of hit and run drunk driver was gross negligence, but not the willful recklessness that would support punitive damages. But see Williams v. Wilson, Kentucky 1998, new statutory punitive damages standard, which required subjective awareness that conduct would result in human death or bodily harm, violated state constitutional juror rights doctrine because recovery for grossly negligent was well-established common law right in Kentucky. What we're basically saying is punitive damages are reserved for malicious conduct, i.e. intentional tort. And again, Owens, Illinois, Inc. No. We're reading 3, strict liability and